In the legal world, evidence is everything. It proves facts, supports arguments, and guides justice. In Zambia, the Evidence Act, Chapter 43, defines how facts are presented and evaluated in court. Today, we explore what evidence is, its types, such as circumstantial, documentary, oral, physical, hearsay, and primary versus secondary, and how it's admitted under Zambian law. Evidence includes facts, documents, testimony, anything that helps prove or disprove a fact in issue. Evidence means the facts, testimonies, and documents which may be legally received in order to prove or disprove the facts under inquiry or the facts in issue. It may also include all the facts, documents, material objects, statements, and any other legal means that can be used to establish a matter in issue. As established in DPP versus Kilburn, evidence must be relevant, making a fact more or less probable. Circumstantial evidence suggests a fact by implication or inference. It doesn't prove a fact directly, but builds a narrative. It may also be described as evidence of facts from which a fact in issue can be deduced. In David Zulu versus the People, the Supreme Court considered the use of circumstantial evidence. The court pointed out the dangers and weaknesses associated with circumstantial evidence. It was stated that it is competent for a court to convict on such evidence as it would convict on any other type of admissible evidence. Documentary evidence includes written materials, photographs, recordings, or any data preserved on paper or digitally. Documentary evidence is any evidence introduced at a trial in the form of documents. Oral evidence is testimony given by witnesses under oath. It's powerful but depends heavily on the witness' credibility, consistency, and the cross-examination process. Oral evidence looks at facts in issue, facts relevant to the issue, facts relevant to the credibility of the witness, facts relating to the admissibility of an item of evidence. Physical evidence, also called real evidence, includes tangible items presented to the court. These items speak for themselves. A weapon, a broken lock, or a piece of clothing can directly link a suspect to a crime. Real evidence refers to the material or tangible objects that can be produced before court for inspection during trial. Hearsay evidence refers to evidence of a witness who relates what he or she was told by another person, who may have experienced or perceived the event him or herself, or who may have obtained the information from another source. For example, Jeff told me he robbed the bank with his brother. This is hearsay and is inadmissible. However, there are exceptions to hearsay, such as dying declarations, public records, and business statements. Primary evidence is the highest quality of evidence, providing for greater certainty and suggests the existence of better evidence. Secondary evidence relates to inferior or substitutable evidence and indicates the existence of original or higher quality evidence. Secondary evidence may be admitted when the whereabouts of primary evidence has been explained. In the case of George Bienga versus the People, it was held that the secondary evidence of the original document is admissible provided it can be established that the original is lost or cannot be produced. Secondary evidence may either be in the form of a copy of the original or by oral evidence. According to the Evidence Act, secondary evidence is only admitted when the original is lost or destroyed, the original is with the opposing party and not produced after notice, it is otherwise impractical to obtain the original. Evidence must pass 3 tests. Relevance. Does it relate to the case? Relevance is one of the key concepts underpinning the whole of the law of evidence. Irrelevant evidence is not admissible, but this does not mean evidence will be admissible simply because it is relevant. Materiality. Is it important to the issue? Materiality means the evidence must be significant or essential to determining the outcome of the case. It's not enough for evidence to just be interesting or related. It must help to establish a fact that is in dispute. Admissibility. Does it follow legal rules? As a general rule, the evidence has to be relevant for it to be admissible. Admissibility of evidence is a matter of law for the judge. That is to say, whether the evidence is admissible is determined or ascertained through the use of statutes, rules, court decisions, and interpretation of legal principles. Whether it's a fingerprint or a document, every piece of evidence matters in the pursuit of justice. Thanks for joining us in understanding Zambia's law of evidence. Justice depends not only on law, but on proof.